Good afternoon, everybody, and welcome to Law and Crime. I'm Jesse Weber here with Kirk Burkhalter from New York Law School, professor out there, my alma mater. It's great to have you here.
Great to see you.
And you're joining us at a great time because we have some breaking news for you in the Scott Nelson case out of Florida. As you can see, we are officially on verdict watch in this case. This is a live feed into the courtroom. We're going to talk about what the jury has to consider, including the fact we can officially announce that that burglary charge, one of the many charges he faced, was just dropped. And we'll talk about maybe why that happened. So this is very interesting. Now, just to take a step back before we dive into the Nelson case, and if you've been following us for this past week, there's a lot to talk about. First, though, we want to talk about Christopher Vasada. As you know, we were following this trial. This is the man who was convicted of gunning down 3 people on Super Bowl Sunday 2 years ago. It was a very interesting trial to follow. Defense tried to point the finger at alternative suspects and say perhaps this man did not have a role in this actual shooting and that he himself was shot during the course of events. Well, it didn't really work out so well for him. These are the victims right here: Kelly Doherty, Brandy El-Sahi, and Sean Henry. He was convicted of their murders, and then it moved over to the penalty phase. The jury officially came back with their verdict and recommended life in prison without the possibility of parole. And you have to think that that is a win for the defense, considering the death penalty was on the table. We'll have an opportunity to talk a little bit more about the Vasada trial a little bit later on. Our focus right now, as you can imagine, has to be Scott Nelson. Now, this was the trial of a man, and we're waiting to see what will ultimately happen here. This is the man who's accused of kidnapping and brutally killing 56-year-old Jennifer Fulford. She was a nanny, a personal assistant to this family. Prosecutors say that this man abducted her from that home, then just proceeded shortly after to steal money from her bank account. Her body was discovered 3 days after her disappearance in a field, duct taped, wrapped all around her head, her wrists and ankles bound, stab wounds to the back and chest. This is a horrific crime, and we were trying to get some sort of explanation. And unfortunately, we got an explanation yesterday, and I don't think any of us were quite prepared for it because the defendant himself decided to take the stand. All right, but really, you tell me, it wasn't his fault, Julio Dominguez. It was his fault about what ultimately happened. What is your perspective on this defendant taking the stand? Because I don't think I've ever seen anything like this.
It's absolutely bizarre, to say the least. One thing, you don't want a defendant necessarily taking the stand. Usually no good can come out of that. And this is a perfect example. The defendant kind of went rogue here, so to speak, and ended up admitting to the crime. It's difficult enough to get a defendant, from a law enforcement perspective, to get a defendant to admit to a crime when being interviewed or under interrogation, let alone on the stand. This is straight out of Perry Mason, so to speak. So he certainly didn't do himself any favors.
I don't know if I've ever seen an episode of Perry Mason just quite like this, and thank goodness. I mean, the stuff this guy said on the stand would give you nightmares. He basically said, when they were talking about the temperature of Miss Fulford's body, he says, well, she definitely got cold. And then he said at another point that zip ties, never leave home without them. I wish I was making it up, but I'm not. Let's play a little bit more of Scott Nelson. Okay, so I want to break this down. Also joining me is Law and Crime legal analyst Matthew Mangino. Now, Matthew, we can talk about how bizarre this whole testimony was and maybe how it hurt his case, but let's take a different point of view. Did this help his case at all? Because we heard the defense in their closing argument to say, hey, you heard from the defendant himself. He never intended to kill Jennifer Fulford. He got angry. He wanted to see someone pay. It was never intention to directly target this woman, but as the defendant said himself, she was collateral damage. You think this helped him at all?
No. Clearly, his confession on the stand, completely and totally implicates him in the death of the victim in this case. We talked about, a Perry Mason moment. Well, usually Perry Mason had to draw these confessions out of individuals. In this case, he stands right there defiantly, methodically explaining why he did what he did. He did it because he's mad at his federal probation officer. And, that's not a justification for killing a stranger just to make a point.
Yeah, absolutely not. And I got to tell you, when I'm watching this, Kirk, when I was watching this yesterday, I'm thinking to myself, actually, stand by. I'm getting word that So, yeah, something's happening in court. I think the judge is making a statement to Nelson. So let's go live. Let's see what's happening. That's an interesting development. Kirk, he was asked whether or not he was happy with his representation. Did he feel that they did anything wrong? He said he was pretty content. I mean, that seems to be, that could hurt him in the future, because if he's happy now, how could he raise later on a claim of ineffective assistance of counsel or anything like that?
I would agree. So it's an important question. I'm not really sure why the judge would ask him that question at this particular point, other than the gravity of the possible sentence. However, I certainly would agree. He has said that he's comfortable with his representation. However, given that's a capital case, there is some leeway, but it's just interesting. I'm just curious why the judge would ask that question.
I wanted to ask you a follow-up question I wanted to ask before we went back to court, and it's the idea here that, you know, he takes the stand, he makes this point. It seems like a slam dunk case. If I was the prosecutor, this is something from law school. You have a defendant who was on the stand admitting to what he did. Why did they drop the burglary count?
Now, it's very curious. I don't know. Now, the burglary here is a lesser charge, right? You have the murder, and in this case, it's a capital crime. It's premeditated and deliberated murder. The kidnapping charge, which led to the murder, I don't know. I mean, it's a lesser charge. If he's convicted of it, it's certainly a felony, but it doesn't rise to the level of the other two charges. Perhaps the prosecution wanted the jury to focus on these major charges, not to mention, as you just mentioned, it's a slam dunk. So he just admitted to the murder. So getting the jury to focus squarely on that, perhaps that's the reason why.
You know, this seemed, again, Matthew, I looked at this yesterday and I'm thinking, what is the prosecution high-fiving each other underneath the table after listening to this? But when you listen to the defense's closing argument, they also picked upon this kidnapping charge. And they're basically saying he didn't have the intent necessary for that kidnapping charge. What are your thoughts about that?
Well, I mean, that's not necessarily the issue that the jury is going to be most interested in. I think that clearly, you know, what has occurred in this courtroom, the testimony, the defendant himself basically saying that, yes, I killed the victim. She's collateral damage because of what, you know, the federal probation department has done to me and a specific agent. You know, so I think that clearly that, you know, arguing about, you know, sort of nibbling around the edges on these lesser charges is not going to save the day for this defendant, especially because of what he said on the stand. And I'm not surprised that the judge conducted a colloquy there, because that is surprising to see a defendant take the witness stand and confess. So I think it's appropriate here for the judge to conduct some colloquy to make sure that that was his decision and that he's satisfied with his attorneys letting him take the witness stand and basically confessing to murder.
Yeah, it would have been interesting if his defense attorneys encouraged him to get on the stand and said, hey, you should admit what you did. I don't think that happened. It is the defendant's choice, and can't say we're that surprised, considering he writes this letter to the judge also saying what he did. He's in that police interrogation tape admitting what he did. It sounded like he wanted his day in court to say to the world at large, this is what happened. Let's put all the blame on the government. Don't know if that's really going to help him, though. We're going to take a break. Obviously a lot more to talk about. Stay tuned here on Law and Crime. We'll be right back. Oh boy, what a day it was to watch this. I know my jaw was on the floor. I couldn't believe what I was listening to, this matter-of-fact kind of way of speaking about, oh, I'll play your game. It's this like level of anger underneath everything. But you made a great point to me, Kirk, and I want to elaborate it. The idea of showing there's an advantage maybe to him going on the stand, or maybe the defense had a strategy of allowing him on the stand. Can you expand upon that?
So I think that the defense, in trying to do damage control and closing arguments, thinking about the lesser of the two evils here, meaning in sentencing, it's a capital charge, so certainly the jury could find that he should be put to death. However, in order to do so, they would have to believe beyond a reasonable doubt that this was a premeditated act versus an intentional act, perhaps someone acting out of emotion, meaning I mean to do so, however, I didn't premeditate and deliberate about it. So you notice in closing arguments, the defense talked about alluded to his emotional state and the fact that he had no plan, that he was angry and he felt that he had no choice but to do this. However, as we just saw on cross, prosecution was able to elicit him to agree that he planned
Right.
on 2 occasions. So I don't know how well that argument would work, but I think that the defense is just trying to make the best of a bad situation here.
Yeah, and Matthew, one of the things some of our viewers were looking at when they're listening to him talk about, I was not in my right state of mind, I had no choice but to do what I did. People thought this was the flavor of a mental health defense, an insanity defense, because a lot of the time the law is if someone couldn't conform their behavior to the law, or they didn't think that what they did was wrong, which is something we see very much in his testimony, why wasn't the insanity defense a factor here? What do you think about that?
Well, the insanity defense is rarely used, and when it is used, it's rarely successful. I mean, you have to be able to show that this defendant could not differentiate between right and wrong, which is not the case here. I mean, certainly this guy knows what's right and what's wrong. He's felt that he's been wronged by a federal parole agent. So his testimony, I think, is obviously just defiant. I mean, he's here to prove a point. He's here to say, you know what? You gave me a rough time. You put me on the streets. Well, you cost somebody's life. There's no way that his counsel would have recommended him testify under any circumstances in this case. Certainly, if he's convicted, you're going to have an opportunity to present mitigation at the penalty phase. But this was his decision, I'm sure, and his decision alone to take the witness stand in this case.
Well, Kirk made a great point that I'm going to bring out in a little bit about, does this defendant actually think that he's justified, going to get some sympathy from this court? Is he going to be surprised if he's found guilty? Let's talk about that in a second. I want to play more of Scott Nelson where, as you just heard, he had this hatred for his federal probation officer and he wanted to kill him. Never good when a defendant just basically implicates himself in another crime. Watch. Okay, so as the prosecutor's laying out the elements of premeditation and showing that it's a plan, you mentioned something great to me earlier on, that he's not schooled in the law. And does he think that he's going to get up there and this is a justification and a jury's going to come back with a not guilty decision because he felt he was justified, because it's not his fault? I'm curious what you think about that.
Yes, absolute possibility. And that's one of the problems with having a defendant take the stand. They are not lawyers. They're not schooled in the law. They don't understand. So he has consistently said, hey, I have no recourse here. I had no other choice. However, there's a problem with that argument. And this is why even those who have suffered abuse over a consistent basis, and then when they take action, they have trouble often using the defense of justification. Has to be an immediate threat and really has to be the lesser of 2 evils. He had a plan for a couple of weeks and went through all these acts and obtained the tools of the crime and so forth. So it's just not going to fly. But in his mind, he feels probably or possibly that this is his best shot to show that he had no choice.
Well, Matthew, let's say these jurors are conflicted about this premeditation issue. They now have the ability to find him guilty of lesser charges: second-degree murder with a weapon, second-degree murder or manslaughter with a weapon or manslaughter. So these 4 different options here. Likelihood they're going to go with one of these lessers and not the first degree.
Well, with regard to the issue of justification, if that's what he's trying to suggest, that somehow he's justified, I'm sure his counsel has sat down with him and explained what exactly justification means, and that what he intends to explain to the jury is not going to meet the standard of justification, and that he's going to take the witness stand, admit to planned premeditated murder, and that's going to result in his conviction. Based on listening to this callous testimony, matter of fact, about the murder of a woman who had nothing to do with any of his concerns, I don't think is going to impress the jury to deviate from a verdict of first-degree murder.
Yeah, saying something like zip ties, never leave home without him, don't think that's going to help him so much. Okay, Professor, I want to start with that first. Is that normal that you'd have an investigator, a detective say, hey, I'll promise you X, Y, and Z if you give us some more information, and then they don't deliver? I mean, correct me for what I'm about to say. Does he have a point?
Well, it's allowed, right? So investigators, police investigators are allowed to be untruthful, right? And courts have held that that's actually okay. They can tell a witness that they have X amount of evidence when they don't necessarily do. You can tell a witness that I'm going to provide you with X, Y, Z if there's no intention to provide it. However, where that crosses the line, if it is tantamount to some type of duress. So in other words, if you're a diabetic and I promise you, okay, I'll get you something sweet to maintain your sugar level, but I have no intention to do so. Now that's coercive, right? But just simply, promising different things like, hey, we can go for a cup of coffee after you're released. That's okay.
Yeah. So, look, again, he's putting the blame on other people and not himself. Matthew, let me ask you this, and maybe we'll have an opportunity to talk about it with both of our guests. The idea here that first-degree murder, it's so much about premeditation, but can't they get him on first-degree murder if this jury finds him guilty of the kidnapping? Because my understanding is if someone is murdered during the course of a felony like a kidnapping, under the felony murder rule, that itself is first-degree murder. Am I understanding this correctly?
That's correct. As I understand, Florida law provides that kidnapping as a predicate offense of murder could result in a verdict of first-degree murder. So, there is a felony murder rule in Florida, but kidnapping as an offense coupled with murder could result in ultimately the jury convicting defendant or this defendant of first-degree murder.
Right, and Professor, the way that I'm understanding this as well, what the defense said in order to get the kidnapping, so I would imagine the jury's going to sit back and first maybe decide the kidnapping charge even before the murder charge. The kidnapping one, the defense was saying that they need this intent to terrorize if you're going to have this kind of kidnapping charge. Are they accurate, or is that really what Florida law is?
Well, there has to be some type of forcible movement in most jurisdictions with regards to kidnapping. The issue here, and it's a strategic decision by the prosecution. So for felony murder, you have to prove that. Hopefully my students studying for the bar are taking a break and watching this. So in order to prove felony murder, you have to first prove the underlying charge, and then of course, show that the murder was in the course of this action. But it's kind of like a deck of cards. So if you fall a little short with the kidnapping, the entire felony murder charge, you risk the entire felony murder charge. It might be an easy way to get here, certainly with this defendant, to simply take the most direct route, charging him with the premeditated murder.
Yeah, that makes sense. But the other thing, Matthew, is even if he didn't technically intend to kill her by going into that house, if he first went in there, wanted to steal some money, then he says, okay, the next thing I'm going to do is kidnap her, then he kidnaps her and then says, okay, now I have to kill her. This is still first-degree murder?
Oh, no question. I mean, you can form the requisite intent for first-degree murder in a matter of seconds. So you don't have to have a whole elaborate plan. If you use some sort of lethal force on somebody with the intent to kill them, that's all you need to do in terms of forming the intent for first-degree murder. So, you don't have to have an elaborate plan, although he did. He did have an elaborate plan, which the prosecution has laid out. So I think, the only reason that the burglary charge may have been removed is to, eliminate that whole, second-degree felony murder issue from the jury's deliberation. Well, this is clearly a kidnapping and a premeditated murder.
I want to talk about that burglary charge and why it was potentially dropped in light of the testimony from yesterday, but not yet. Let's take a quick break. When we come back, more of the testimony of Scott Nelson.